Hi everyone, this is Matthew Lyman, your host of the Landlord Advocates, where we help landlords become better landlords. You may have seen in the thumbnail and in the title how we referenced how Governor Andrew Cuomo of New York has extended the eviction moratorium past August 20, 2020. Now you may be saying, Matt, we didn't see this in the media. We didn't see it in the newspaper. We didn't read it there. We didn't see it in any executive order. We didn't see it on social media. What are you talking about? What do you mean he extended it past? And you know what? You're correct. He literally did not extend it on paper, but the executive order that he had on May 7th did extend it into October, or maybe even farther, not August. And we're going to explain and show you how he did that in our video. Landlords, it's going to be a bumpy ride. Buckle up those seatbelts. We're in for a ride. Here you go. On May 7th, Governor Cuomo had his daily press briefing, and he passed another one of his executive orders, 202-28. It was very long. We took a paragraph that focuses on the landlord-tenant issues. We took that paragraph out of the executive order and we analyzed it. We're going to read you that specific paragraph, but we're going to take out the part that really has an effect on landlords and explain how it is that this moratorium has been extended much further. Here's how it goes. There should be no initiation of a proceeding or enforcement of either an eviction of any residential or commercial tenant for non-payment of rent, or a foreclosure of any residential or commercial mortgage for non-payment of such mortgage, owned or rented by someone that is eligible for unemployment insurance or benefits under state or federal law, or otherwise is facing financial hardship during the COVID-19 pandemic for a period of 60 days beginning June 20, 2020. Now the part that we took out of that, and it directly affects us, the landlords, is this. There should be no initiation of a proceeding of an eviction for non-payment of rent of a tenant. Now, what is a proceeding? It is not the rent reminder and a 14-day notice that is given to a tenant to say, listen, you need to pay. Those are letters of intent that the tenant needs to make amends with you, make payment, and if not, then you would take them to court later on. Those are what's called predicate notices. Those can still be served. Now, what is the proceeding? A proceeding is when you, the landlord, or your lawyer, or a firm such as ours with our lawyers, goes to the court and asks and pays for an index number that is put on the documents that you gave to the court. Those documents are then signed by your attorney, by the court clerk, or by the judge's rubber stamp, and then given a court date to be heard in that court of jurisdiction. That is what the proceeding of an eviction is. That's the start of the eviction when the government gets involved. Now, when we analyze that, we want to know, how is it being extended? How do you get that it's being extended? Well, here's where we explain that. If you are eligible for unemployment or collecting unemployment, that's a no-brainer if you're collecting it, that the eviction is staying until August 20th, 2020. But there's more to it than that. Here's the question that we have. When we talk about eligibility of unemployment, what's the determining factor on that? Right now we have a couple of cases that open that question up. We have a tenant right now who I was involved with that we had served notices on. I was particularly involved in this case. Well, we had served the notices on the male and female tenant. Well, that tenant, those tenants, gave us a lot of stories. They knew more about the law. They knew more about the moratorium. Well, they were actually wrong, and I explained to them how they were wrong. But in that case right there, the male tenant quit his job. How do we know that? The landlord told us. Well, how does the landlord know? Well, the landlord lives downstairs, and the tenants live upstairs in this two-family home. I mean, that doesn't mean he knows he quit his job. Yes, it does, because the landlord and the tenant work together in the same building. So when that tenant, if this were to go to court, would this tenant be able to say, I've been furloughed, I've been laid off, I don't have my job anymore, I'm eligible for unemployment? Well, we know the backstory. He quit. When you quit, you're not eligible for unemployment. We have another case where the landlord said that the tenant has been fired from his job because he was caught smoking marijuana on the job, so he was fired. Can that same individual go to the court and say, I've been furloughed, I've been laid off, I'm not working, I'm eligible for unemployment? That should not be. There should be a determining document presented to the court that unequivocally states that that individual, that tenant, is eligible for unemployment. And that document should be from the state unemployment office, whether it be New York, California, Florida, Massachusetts, stating that that tenant, X, Y, and Z, are eligible for unemployment. If that's the case, then yeah, the eviction is going to be stopped. But here's the other part of this equation, the financial hardship aspect. That's the other part. We alluded to in our previous video, what is the financial hardship? We're going to touch upon that right now. Is the financial hardship that the tenant had to buy a facial mask? Is it that they had to buy hand sanitizer, gasoline to fuel their car, groceries for their home, and the prices have increased? Well, this happens to all of us, and when the price increases for the tenant, it increases for the landlord. Can a tenant say that my child is no longer in school, and the child eats me out of house and home, and therefore I'm spending $300-400 more a month in groceries, therefore it's a financial hardship? Can a tenant say that? We believe that Governor Cuomo deliberately made it ambiguous when he said financial hardship. He did not clearly state what is and what is not a financial hardship. Because of that, it's basically left to the discretion of your judge to determine whether or not that tenant is actually facing a financial hardship. That being said, to take a tenant to court for non-payment of rent, and if they meet any one of those three pre-qualifying factors, your case could be dismissed right then and there if you file before August 20. Or would the court possibly grant the relief that you're asking for, that relief being a judgment for the amount of money that is owed to you, and an immediate warrant of eviction, but stayed until August 20th, at which time the sheriff can remove the tenant on August 20th or any day thereafter? We don't know what the court will do, because it hasn't been raised, it hasn't happened yet in the court. Will the court dismiss, or will they will not? Or what will they do? We don't know. That's a big question. If that were to happen, if the court were to dismiss the case, then the landlord would have to start the eviction all over again. Which means that we now know unequivocally that the court date would have to be after August 20, 2020. After August 20. We can still serve all those notices before, the rent reminder of the 14th day, but the court documents cannot be time-stamped until probably August 21, which I believe is a Friday this year. Can't even be time-stamped until that day just to protect your backside. They can't have the index number, you can't pay for that. Therefore, what will happen here in New York State, your court date will more than likely be on the second or third week of September. Now, if they're in court and the tenant raises the hardship issue, I have no place to go, COVID-19 has affected me. I gotta talk to DSS. I gotta talk to these agencies over here that might help me. I need more time. I need to have a trial. Once the tenant says that, the judge could very well and more than likely will grant them a trial. Now, prior to June 2019, here in New York, 2019, you could have had that trial later on that day, later on that week, within that 10-day time frame. But in June of 2019, New York State passed a law and Governor signed it called the Housing Stability and Tenant Protection Act of 2019. We're going to go in depth on that act in another video. But now, because of that act, that trial is 2 weeks later, at least 2 weeks later. So in that case, the tenant may have bought themselves more time. So now what happens is, 2 weeks later, all the parties are in court to discuss what's going on. Oh, wait a minute. The tenants are not here. Where are they? They don't come to court. We have seen numerous times since this act has gone into law that tenants don't show up to court. It just buys them 2 more weeks of not paying rent and not having to leave. If they do that here, now you're looking at being in court in sometime, or not in court, but having the sheriff having them out sometime in October. Who knows? You could even be in court in October. Who knows? Depending upon the municipality in which you brought this case. So now, it's not August 20. If the tenant proved that they were not working and that they were not having any money, and if they can prove that I have no money coming in and I'm eligible for unemployment and I have a financial hardship, they can stretch this case out for a while. That's not fair to you, the landlord, because you're not getting any rent, but yet the tenant has more time to stay. So on paper, the moratorium says August 20, 2020, but theoretically, this can go on into October where you are getting no rent whatsoever. On our channel and on other channels, and with our landlord clients, we have heard them issue a lot of complaints, and they've all had the same chorus, the same choir has been saying the same thing, and that is that if a consumer of a good, a tenant of an apartment, a consumer of a good, goes into a Price Chopper, a Hannaford, a ShopRite, Walmart, Walgreens, wherever, and goes into that establishment and walks out with that good right here and now, they can be arrested for larceny. If they put up a fight with a loss prevention team, it could rise to the level of a robbery for taking that item from the store. But yet, the governor of this state and in other states, with these moratoriums, eviction moratoriums, have in essence done that to landlords. They have said that the tenant can stay. They're not saying that they don't have to pay, and hopefully the good tenants are paying, but it's saying that even if the tenant is not paying you, you can't evict them for a few months. So they are consuming your good, your apartment, your house, but not having to pay you for it, and there's nothing that you can do about that. There's nothing that you can do. That can go on for 6 to 8 months, if not more. That is absolutely not fair. One of the things in our local newspaper, the Daily Gazette here in upstate New York, had a story yesterday in the New York Times. And it had to do with New York City landlords are facing a catastrophe because tenants are not paying the rent. In the next 5 weeks in New York City, the property taxes are due. The article went on to say that that is an enormous amount of revenue that allows the city of New York to continue on a day-to-day basis with the administration of the city. But yet, there's been no postponement of those taxes on the residential and commercial landlord. No postponement whatsoever. Mayor de Blasio endorses the actions of Governor Cuomo. He actually wasn't taken further. So here you have government entities that are saying you cannot do anything to get rid of that person stealing your apartment by not paying for it. There's nothing that you can do, but yet we want you to pay the taxes that we impose upon you for those same properties. A lot of attorneys and lawyers and a lot of people out there are saying that this is in violation of the Fifth Amendment to the U.S. Constitution of the Takings Clause. That touches upon eminent domain and takings clause. It relates also to the 14th Amendment of the U.S. Constitution, which takes the meat and potatoes aspect of the takings clause and applies that to the states and municipalities. That they too cannot do that. They cannot take your property without giving you just compensation for that. Well, that is what's happening here now in New York and California, and I know many other places, that they're taking the property. There was a case in 1922 in front of the United States Supreme Court that related to this. And the very esteemed, very intelligent, very renowned Supreme Court Justice Oliver Wendell Holmes offered the majority opinion. He authored the majority opinion in that case. And part of what he said was this: that the court held that if a regulation went too far, it could constitute a taking that would require just compensation by the government. Now the question is, how far is too far? Well, we believe at the Landlord Advocates, and we know that we're speaking for all of the landlords across America, that this is too far. You have imposed upon us taxes that have to be paid for those properties. We still have the upkeep and the insurance that have to be paid. And there's been no mortgage forbearance. Then we have to pay those mortgages. But we clearly have to pay the taxes to you, the government. But yet you have arrested our ability to remedy the situation of tenants not paying the rent to us. If that's not takings of our property, by not allowing us to get positive commerce from that property, then we don't know what is. But that clearly has gone too far. Now our team that has almost 100 years of experience in real estate and law have analyzed this. And this is our interpretation of that Executive Order 202-28. We believe that landlords should be able to file for an eviction right now. Whether the tenant is on unemployment eligible or not, working full-time, having a financial hardship, they should be able to file for that. They should be able to get a judgment of eviction. They should be able to get an immediate warrant of eviction, but stay until August 20th, 2020. We don't agree with that stay date, but it is what it is. Some things you just can't fight. We don't agree that it should be, but it is. But the landlord should be able to do that, to acquire that deed. Now here's another thing that we're looking at too, when it comes to filing an eviction for non-payment. The moratorium here in New York went from March 20th on. Well, if rents were due on the first of the month, then they would have owed March's rent. What about those tenants that owed January, February, March? The landlord tried working that out with them, tried making a payment arrangement, tried being good to the tenant, and nothing happened. So therefore, they want to file an eviction now. Should they not be able to file that eviction based solely on whatever rent was due from March 2020 in the arrears? Yeah, they may owe April and May, and what maybe June and July or whatever. But if the landlord chooses to exclude that amount and take the tenant to court based solely on that rent arrears, we feel they should be able to. Because the COVID-19 pandemic had nothing to do with whatever rent was due from March prior. They should be able to file an eviction. Now here's the other thing that goes along with that. Landlords have already been in court and their cases have been adjudicated, which means that the court has rendered a decision in their favor or not. In the case of the landlords who have had a decision rendered in their favor, and they've provided the warrant to the local marshal or the sheriff, those evictions should have already been completed. Why? The same thing as I stated before. The eviction was granted based upon, let's say, a non-payment, and the rent that was due had nothing to do with COVID-19. There has been some movement out there by tenant and tenant advocates to, when the courts reopen and the sheriff reopens, that the 14 days that is provided in New York State by the sheriff, when the sheriff comes and gives the notice to the tenant, it used to be 3 days. 72 hours later, the sheriff can come and remove the tenant. Well, now, because of that act of 2019, it's at least 2 weeks after the sheriff serves the warrant on the tenant before the sheriff can come back and remove that tenant from the property. Those should have already gone through because, again, the tenants were not hampered by COVID-19. It was not a crisis for them. It had nothing to do with it. That should have already been granted. But more than likely, that's not going to be allowed to happen. The landlord will not be able to take it to court because what's going to happen in court? If the case gets dismissed. So landlords, we understand this is wrong. But there is one out that you still have. And that is to file a holdover eviction on the tenant. It has nothing to do with the rent that they may owe. It's just that you want them gone. So the hurdle that you have to jump to show that they have not been affected by the COVID-19 crisis is not present. You should just be able to get the eviction. You have to make sure, though, that by looking at your lease, and the time of them being a tenant of yours is considered by giving them the appropriate notice required by law. And at the same time, give them or file a small claims case against them for the back rent that they owe. We alluded to this in our prior video at length. Feel free to go back to that prior video, watch that, and it will show you in detail how you can do this. Again, we don't agree with it, but it is what it is. Landlords, we understand your frustration, your anger, and despair over these actions of the government. We're with you. We think it's awful. These actions by New York State government and other governments that have enacted this legislation has been totally unfair to the landlord. They have not considered what can happen to us. We know that the tenants out there who choose not to pay the rent, who are thumbing their nose at the landlords to say, you can't do anything to us, ha ha. We know that they're laughing at us. We know that they will come out of this crisis financially stable. Why? Because they don't have to pay the rent. Yeah, will you be able to get a judgment afterward? Sure you can. But as 99% of you landlords know, you're not going to collect on that money. You're never going to see it. So what good is a judgment? It's not. The tenants who choose not to pay will come out of this financially stable. But will we, the landlords, do the same? We hope so. We really hope so. Landlords, subscribers, we really do wish you well. Remember, those of us here at the Landlord Advocates, we are here for you. We are here with you. Subscribe to our channel. Please leave comments down below. We love reading them. We love responding to them. We are here again for you. Hit the notification bell. More videos are yet to come. Take care, everyone.